Welcome to the 42 Bedford Row webinar on understanding damp and mould claims. I'm Stefan Liberadzki. I'm a barrister in the housing team, and I'll be hosting this webinar along with my colleague Krishma Patel. We're part of a large team of housing barristers here at 42 Bedford Row. Our team covers all areas of landlord and tenant, as well as other areas relevant to the social housing sector more generally. We're pleased to see a very high turnout for today's webinar, and we think this reflects a growing number of damp and mould claims across both the private and the social rented sectors. There was a recent report in October of this year by the Housing Ombudsman, where they said they had seen a 50% increase in damp and mould complaints since they had published their call for evidence on the issue earlier in the year. Many councils and housing associations have also reported a significant growth in damp and mould claims recently. Now, there's a number of possible reasons for this trend. They may include, for example, developments in the claims management market and people spending more time at home in damp and mouldy conditions since the COVID pandemic and lockdown started, as well as underlying issues with the housing stock in the country. In today's webinar, we're aiming to give practitioners an overview of legal claims that may arise from damp and mould. There are, of course, other avenues of redress, such as complaints to the Housing Ombudsman or perhaps arbitration schemes. But today we will focus on claims that are brought to court. I will cover the first three areas. These are, firstly, what is damp and mould and when is it disrepair? Second, when is it actionable? And third, is there a time limit to bring a claim? Krishma will then talk about questions of causation, including whether it may be the tenant's fault or not, and how to assess the value of a claim. We hope this will give you an informative and practical overview of damp and mould claims. Please do remember, of course, as always, that what we say is not legal advice. And if you do need advice on a particular case or point, do get in touch with a member of our housing team. So moving on to the first area, what is damp and mould disrepair? Now, of course, there's no legal definition of what damp and mould is, but we'll start with a practical overview of the types of damp you normally see. But there are three that we generally see. The first is condensation. This is when you have warm, moist air inside a property and it comes into contact with a colder surface. That might be, for example, a poorly insulated external wall. This causes moisture to condense on the surface. You usually see that through gradual mould growth on the damp area. The second is rising damp. This is when water enters a building from the ground and rises up through the walls. For obvious reasons, you normally see this in a ground floor or a basement property. Then it's more common in Victorian homes, which were built before there was any regulatory requirement to have a damp-proof course. You may also see them in properties that are more recent, but have a poorly installed damp-proof course or one that has failed. It usually shows itself through staining or tide marks in the wall and plaster and damage to the skirting board through damp. The third kind we see is penetrating damp. That's when water comes through the wall, roof or ceiling from somewhere outside of the property. That might be the exterior of the building, for example, rain leaking through a roof. But it might also be issues with defective plumbing inside the building that then leaks through the wall into the property. This type of damp tends to appear as a patch that spreads, and it can spread quite quickly on interior walls and ceilings. Of course, the pace of the spreading will depend on how quickly water is coming through. Mould growth you then see usually as a consequence of persistently damp conditions on the surface of a wall. And you'll know that some species of mould can be harmful to health by releasing toxic spores. Those can cause allergic reactions, exacerbate asthma, and even cause lung infections. And Krishma will talk later on about personal injury claims that can be made as part of disrepair claims. However, just because there is damp or mould in the property doesn't automatically mean it's in disrepair. Let's look at the repairing obligation that is relied on in nearly all claims, which is Section 11 of the Landlord and Tenant Act of 1985. This applies to nearly all residential tenancies, unless they're for a fixed term of more than 7 years. Do note, though, that it doesn't apply to licenses, which aren't leases. You might get those, for example, in bed and breakfast temporary accommodation. Subsection 1A of section 11 requires the landlord to keep in repair the structure and exterior of the dwelling. There's two important parts there, keep in repair and the structure and exterior. Looking first at what the structure is, you need to distinguish that from parts that are just decorative. It is generally accepted now that plaster, which forms part of or is applied to walls and ceilings, is part of the structure of a premises or dwelling. This comes from a Court of Appeal decision, Grand versus Gill. The citation is 2011 EWCA Civ 554. The leading judgment said this: I would also regard plasterwork generally, including that applied to external walls, as being ordinarily in the nature of a smooth constructional finish to walls and ceilings, to which the decoration can then be applied, rather than a decorative finish in itself. I would therefore hold that it is part of the structure. What it meant in that case was that Miss Grand's flat, the wall and the plaster on the ceilings of her flat form part of the structure for which her landlord, Mr. Gill, was responsible. You can distinguish that from decorative finishes like paint or wallpaper, which aren't part of the structure. What this means is that the tenant needs to show there has been damage to the plaster underneath. This will usually be the case when you have rising or penetrating damp, which soaks into the plaster and makes it soggy and crumbly. But in cases of condensation, which condenses on the surface, it may be a case where if it's at a lower or minimal level, it hasn't soaked through the wallpaper or paint into the plaster itself, and it may be arguable that it doesn't count as disrepair at all, at least until the plaster becomes damaged. There are two caveats to bear in mind here. One is that if the plaster becomes damaged as a result of damp and spoiled, and that means that the paint and wallpaper are spoiled as well, the landlord in practice will be liable for that, and the tenant can claim the cost of redecorating. And of course, in practice, if you have to carry out remedial works to replace plaster, that's going to involve making good the decoration once that work is finished. The other caveat, and this is important to bear in mind, check the terms of the actual lease. We've talked about section 11, which is the implied obligation in nearly all leases, but some leases have stricter obligations than the landlord than what section 11 sets out. This may be the case particularly in social housing tenancies. Do look at whether there is anything that puts a responsibility on the landlord for things other than the structure or possibly the decorations as well. But going back to section 11, the second bit to look at is what the meaning of keep in repair is. This is interpreted by the courts as keeping the property in the same condition as it was at the start of the lease, not making it better than it was to begin with. When you apply this to damp and mold cases, in practice, this means you need to find out why the damp has occurred. Is it caused, for example, by the tenant's actions that cause excessive condensation? And Krishma will cover this in more detail in the causation section. Is there a failure by the landlord to keep part of the structure in repair, for example, a hole in the roof or in the wall that causes penetrating damp? Or is there a flaw in the design or building of the property in the first place? And the landlord may say in that case, it was like that to start with. It's not actually disrepair. You might see this argument, for example, if you have a property that just isn't well insulated. It has drafty single glazed windows and poor insulation. That may cause condensation damp or make it more likely, but the landlord can usually say that fixing that problem would mean upgrading or improving the property more than just repairing it. If they're going to have to put in double glazed windows or new modern insulation, for example, the tenant will end up with something better than they got in the first place. This distinction, though, isn't always very easy to make in damp cases. There have been quite a few reported court appeal cases on penetrating damp, and in particular, whether a landlord is expected or required to install a damp-proof course to stop this from happening. There was a case in 1940 called Pembury against Lambden. This was a converted cellar in an 1840s building. It suffered from rising damp because there was inadequate damp proofing around the walls to protect it from moisture in the ground. In that case, it was held that installing a damp-proof course would be an improvement, and the landlord therefore wasn't expected to do it. It didn't come under the heading of repair. But there have been later cases which have held the opposite. One case to look at is Elmcroft Developments Limited against Tankersley Sawyer. The citation for that is 1984 15 HLR 63. This was a flat in a purpose-built mansion block. It was a high-class block in a wealthy area of South London. In this case, it was said that the landlord was required to upgrade a damp-proof course, which was inadequate and old, and they were expected to do that by silicon injections into the wall to create what's known as a chemical damp-proof course. If you are faced with a case where the underlying issue is to do with damp proofing, it's a fairly common sense question of fact, looking at all the circumstances, and there can be room for argument both ways on how much the landlord is required to do. You should look, for example, at the age of the property, what type of property it is, even the area it's in, what type of damp proofing, if any, do similar properties usually have, and how costly or disruptive would it be to install a new modern damp-proof course. These are points that you should always, in appropriate cases, ask your expert surveyor to consider, but in any case where rising damp is suspected. I'll give you one other more recent example, a case called Eyre and McCracken. Eyre is E-Y-R-E. This is a 2001 case from the Court of Appeal. This was slightly different because it was about a tenant who had a repairing obligation. They had a 7-year lease, which required them to keep the property in repair during the lease. Now, the landlord at the end of the tenancy argued that the tenant was required to put it back in repair by installing a damp-proof course to remedy a persistent problem with damp. But the Court of Appeal said that the tenant wasn't required to do that. This was an old Victorian terraced house, and there was evidence that damp-proof courses were not the norm in properties of that type. What was also relevant is that when the landlord let the property to the tenant in the first place, it was already in a fairly poor condition to begin with. And taking all those together, the Court of Appeal said that putting in a damp-proof course would be an improvement, not a repair. So once you've looked at the underlying cause and what might be required to remedy it, you can then consider when it is actionable, which we'll move on to shortly. As a side note, though, do you consider that there is a more recent statutory obligation in landlords that was introduced in 2019, March 2019, and that's the fitness for human habitation requirement, which is found in now new sections 9A through to 9C and 10 of the Landlord and Tenant Act 1985. This requires landlords to ensure that the dwelling is fit for human habitation. And section 10 contains a list of topics or issues that can be relevant to fitness for habitation. One of those is freedom from damp. But the courts have said that the obligation is only breached if it's so defective, if the property is so defective in one or more of these respects, that it's not reasonably suitable for people to occupy. As a result of that, it's generally a lower standard than the Section 11 repairing obligation. You can have a home that is in disrepair. There's some stained plaster, for example, but it's still fit for habitation. It has to get quite bad in terms of persistent damp and severe mould before it might be considered unfit for habitation. But claimants can and do rely on it. Bear in mind, though, in most cases, it probably won't add anything to the Section 11 disrepair claim. Now, if you have damp and mould that meets the definition of disrepair, it will usually only actually become actionable through a court claim once the landlord has been given notice of the issue and has failed to remedy it within a reasonable period. This is the requirement of notice that you'll no doubt be familiar with. There is an important exception to that, though. If the underlying cause of the damp is a defect in a part of the building that the property sits in, and that part of the building is in the landlord's control, the landlord is going to be liable as soon as a problem arises whether or not they've been given notice by the tenant or indeed had any time to fix it. The landlord is fixed with knowledge of the defect that is under their control, and they are assumed to be responsible for preventing problems from arising in the first place. To give you a couple of examples, you have a block of flats where there's a soil stack pipe which runs in the void between flats. That springs a leak which penetrates through the internal wall of a flat. The landlord may not know about this at all until the tenant discovers it soaking into their walls and reports it to their landlord. But the landlord is actually liable for damage caused as soon as it's arisen in the first place, because the pipe is not within the demised property, the rented property, it's within the common parts that remain under their control. Another example, you might have a house which is converted into flats, and there's a hole in the roof which lets rainwater into the top floor flat. And again, assuming that the lease gives the landlord control or retains control of the roof itself, and the landlord will be immediately liable for that. Now, in some cases, it might not be clear exactly where the problem is, whether it's in the tenant's demised premises, to use the legal term, or the landlord's retained parts. So it might call for a thorough inspection by a surveyor. There might be a need for more involved works to gain access to identify the exact source of a leak and penetrating damp. And you may also need to look at the lease itself and see exactly how the demised premises are defined and delineated. For example, where is the dividing line in a roof and the internal ceiling between the landlord's part and the tenant's. On the other hand, though, as I say, if the underlying problem is inside the flat, then the tenant has to give notice and give the landlord a reasonable period to act on it. For example, a window frame that's rotted and allowed condensation to build up as a result, or there's a pipe inside the flat which has a leak inside the premises and that soaks into the walls and causes damp and mould. Now, the requirement of notice is not a strict one. The landlord doesn't have to be given full details of the problem or full details of extent. The legal test is, has a tenant given them enough information that would prompt a reasonable person to investigate further? So usually if a tenant complains to their landlord, there's mould or there's damp in my flat, they don't need to have said necessarily exactly where it is or how much it's spread or how long it's been there for. You'll of course want to find that all out, but as soon as a landlord's been given that general detail, they're put on notice of the problem and the clock starts ticking for the reasonable period to investigate and fix it. It also doesn't necessarily have to come from the tenant, the notice. You might, for example, have an environmental health notice served by the local council on the landlord. That's sufficient to give them notice, even if the tenant might not have directly reported the problem to the landlord yet. So what is then a reasonable time period to remedy the problem? This depends on all the circumstances. There isn't a legal rule or a fixed deadline in most cases. Again, look at circumstances such as what is the type of work that's going to be required, what is the property like, how easy is it to gain access, and how invasive will the works be. You can also, in some cases, consider who the landlord is. Compare an individual landlord who's let out their second home to a large housing association. The individual might argue that they don't have the same resources to get a problem, particularly a complicated and costly problem, fixed as quickly as a housing association that has a panel of contractors might be able to do. And now that doesn't absolve landlords from fixing defects which are disrepair and they've been given notice of. They have to do it even if it is potentially quite costly. But you might be able to argue that they should be given a longer reasonable period to do so. Do always ask an expert surveyor to comment on what would be a reasonable period to fix a problem of damp or mould, based, as I say, on what the underlying problem is and what it will take to be fixed. If you're defending a claim, always record evidence of every step that's been taken to remedy a problem. and why any delays have occurred so that you can explain it at trial if needed. There is one exception where to what I said, that there's no general legal rule with a fixed deadline. Secure tenants of local authorities do have a statutory right to have certain types of defects fixed within a prescribed period. There is a list in the 2014 regulations that apply to secure tenants of local housing authorities, a list of particular problems, and that includes leaking pipes and roofs. It doesn't, though, include damp and mould specifically. The details of these regulations are outside the scope of today's webinar, but do note that they only cover problems that would cost less than £250 to resolve. So more complicated leaks, damp and mould claims generally aren't going to be covered by these regulations anyway. Let's turn then to limitation. Is there a time limit for bringing a damp and mould claim? There is, in general civil claims, a 6-year time limit to bring a claim for a breach of contract or a tort, which is what a disrepair claim would come under. Do remember, though, that if there is a personal injury claim involved, for example, severe mould is said to have caused lung disease, Krishma will talk more about this later, there's a shorter time limit. That's 3 years from when the tenant first gained knowledge of the personal injury that they have suffered as a result. But let's stick with the general 6-year time limit. It's important to bear in mind that this doesn't mean that there is a 6-year time limit necessarily from when the damp and mould first appeared. It starts running when the cause of action arises, and that's after the steps that we've gone through already. So has the damp and mould reached the level of disrepair? If it's due to a defect in the premises, has the landlord been given notice, and have they had a reasonable time period to fix the problem? And it will only be at the end of that reasonable time period, they still haven't fixed it, that the cause of action arises for the tenant, and then the 6-year clock starts running. So, for example, a tenant reports a leaking roof that's causing penetrating damp. The landlord, let's say, should have fixed it within a week, but it takes them a full year to do that, during which the problem gets worse. The tenant needs to bring his damages claim to court within the following 5 years from the date when the landlord should have fixed it, so a total of 6 years from that date, in order to benefit from their entire claim. If it's been fixed after that full year, but he makes a claim, let's say 7 years later, the landlord is going to have a complete defence. They can say the problem ceased to exist more than 6 years ago, and it's therefore barred by limitation. Other cases, though, the limitation defence may not succeed to the same extent for a landlord. If a landlord in that scenario of the leaking roof does nothing at all for a period of several years, they simply ignore the problem or for whatever reason don't get it resolved. If more than 6 years passes, it doesn't mean that the tenant completely loses his right to bring a claim in the situation. The reason for that is that the landlord's failure to act over the period of years is what's called an ongoing breach. Each day that they don't get the problem fixed when they should have is a new breach and technically a fresh cause of action. So in practice, what this means, if you bring a damp problem to court that's been going on for a long period, more than 6 years, let's say 7 or even 10 years, you still have a claim, but you are limited to claiming damages for the most recent 6 years. So the court will assess damages based on the inconvenience, distress, any personal injury, and any special damages for that 6-year period. I said personal injury, of course, that's subject to a strict 3-year limit. So that covers the first 3 areas. I'm now going to hand over to Krishma, who will talk about causation and how to assess the value of the claim.
Causation, and is it the tenant's fault? So in terms of any loss claimed, generally speaking, the tenant would need to prove loss and that the loss was caused by the landlord and that it's not too remote, i.e. that it's within the scope of the landlord's responsibility and it should be brought into account in accordance with the usual principles for damages. There are some issues, in my view, to look out for on the point of causation. So first of all, the issue of notice. So, of course, the landlord, as Stefan has said, in certain situations, needs to have notice of any defects, specifically in relation to damp and mould, in relation to this talk. But has there been, for example, any delay by the tenant in providing that notice? And if there has, can it be shown that that delay led to the damp or mould getting any worse? Another issue to consider is, has there been a breach of duty on the part of the tenant to use the premises in a tenant-like manner? So, for example, that might include not ventilating or heating a property properly, overcrowding, allowing steam from the kitchen or bathroom to travel into other rooms in the property, or it could be caused by something in the property. For instance, was a bath left running? And have any of those issues caused the damp to worsen in a way that would have not occurred had the tenant been using the property in a tenant-like manner? Another thing to think about is whether the tenant, for example, has refused access when the landlord has tried to deal with the problem. And if they have, has there been a delay again? And what impact has that had on the damp and mould? It's also very important to consider the cause of the leak and where the damp emanates from. So on this point, the tenant, for example, might be in a block of flats and might be suffering an area of damp to their bedroom ceiling. It would be wise in this situation to check where the leak is coming from. If the cause of the leak is unclear, the tenant may be found not to have discharged their burden of proof to establish disrepair. If, for example, the leak arises from an area within the control of another leaseholder, then it's more likely that that leaseholder will be responsible for the damage caused to the premises. And in this regard, subsection 3A of 11 of the Landlord and Tenant Act is relevant. If there is a need, for example, to carry out works or repairs outside of the premises, so for instance, taking the example of the flat above, and the landlord has tried to use all reasonable endeavours to enable them to carry out the works and or repairs, then in that situation, that may well provide a defence under section 11, subsection 3A. There's a case called Niazi Services Limited versus Vanderloo, 2004 Court of Appeal Authority, which I'm sure a number of you are familiar with. And in this case, the tenant complained of an inadequate supply of water to his flat and sought to invoke Section 11 of the Landlord and Tenant Act. The tenant's landlord was the long leaseholder of the flat occupied by the tenant. However, the defect in that case was caused by a problem in another part of the building in which the landlord had no interest, and namely were caused by works to a restaurant on the ground floor. Now, whilst this case deals with the supply of water and not damp, the principle is relevant in that it was held in that case that on a true construction of Section 11, the landlord's duty only extended to those parts of the building in which he had an interest. So again, it is important to determine for issues of causation and for the purposes of a potential defence, what the cause of the leak is and whether actually the cause of the leak is something that the tenant has done or whether it emanates from a different flat or premises entirely that the landlord doesn't have an interest in. I'm going to move now to the issue of quantum. So on the point of quantum, there are a number of legal principles that need to be borne in mind. The first is that the purpose of damages in this area is to place the tenant financially in the position that they would have been in had they not suffered the breach of duty. And that's a principle that stems from the case of Calabar Properties versus Stitcher. Another important authority in this area is the case of Wallace versus Manchester City Council. So in this case, the Court of Appeal held that damages for disrepair to premises let to a tenant were damages for distress and inconvenience, which could be calculated either by reference to a notional reduction in the rent payable throughout the period for which the disrepair existed, or by reference to a global award of general damages for discomfort and inconvenience. The case of English Churches versus Shine at 2004 Court of Appeal Authority also approves a notional reduction in rent, a global award for discomfort and inconvenience, or a mixture of the two approaches. In the case of Earl versus Charalambous, 2006 Court of Appeal authority, the Court of Appeal in that case confirmed, in a tenant's disrepair claim for damages representing his distress, discomfort, and inconvenience, notional reduction in rack rental value over the relevant period will be an appropriate measure, even in the case of a long lease under which only ground rent was payable. Now, in that case, it was noted that rack or market rents were a good indication of the value of fully enjoyed occupation to tenants. If the breach deprived the tenant of that enjoyment for a significant period, a reduction in rental value was likely to be the most appropriate starting point. And so for a tenant that's in occupation, that means assessing the loss of comfort, loss of enjoyment, inconvenience, disappointment, and distress of the disrepair. But what about a tenant lawfully not in occupation? In this regard, the case of Mourjani versus Durban Estates 2015 Court of Appeal Authority is relevant. So in that case, the appellant, Mr. Mourjani, he owned a long lease of a residential flat that was within a block of flats where the common parts were in a state of disrepair. The key points of argument in that case were whether Mr. Mourjani could claim damages for the period of time when he was not residing at the flat, and if so, how such damages should be calculated, and whether any loss suffered by Mr. Mourjani should be based on impairment of the amenity value in Mr. Mourjani's leasehold interest or discomfort, inconvenience, and distress actually suffered as a result of the landlord's breach of covenant. In that case, the court concluded that Mr. Mourjani's loss stemmed from the effect on his rights of amenity that were granted by the lease, rather than the resulting discomfort, inconvenience, and distress he may have suffered. As a result, the claim was still valid, despite the fact that he wasn't actually living in the premises at the time that the damage was caused, and he didn't return until the damage was made good. The landlord's breach in that case was sufficient to cause the tenant some loss of amenity under the lease. Because he was living elsewhere, however, Mr. Mourjani's loss could be mitigated. Even though Mr. Mourjani had not intended to mitigate by living elsewhere, the fact that he was not in residence at the time of the leak was nevertheless an adequate form of mitigation. And so the Court of Appeal held in that case that whilst damages are to be assessed according to the rental value of the premises during the period that the premises were affected, they could be awarded to the appellant in consideration of the impact on his rights of amenity. However, they should be reduced because of his living arrangements, which at the time meant that he wasn't in the property. And also they were reduced to reflect the fact that damage was purely cosmetic and to reflect the lack of severity of the landlord's breach. And so for a tenant that's lawfully not in occupation, that means assessing damages for interference with property rights, as well as the distress and inconvenience of that interference, which usually will be a lower sum than if the tenant was in occupation. Now, a further principle to bear in mind is that damages can also include the effects on those for whose benefit the tenancy was entered into. So, for instance, the tenant's family. That was a point made in the case of Jackson versus Horizon Holidays Limited, 1975 authority. Also, in the case of McCall versus Abeles, Lord Denning had explained that the question is whether the offending act substantially interferes with the tenant's freedom of action in exercising his rights as a tenant. Now, pursuant to all of that, and pursuant to the case of Wallace, and in summary, there are two methods for calculation for the purposes of determining damages. You have the global or the annual tariff calculation, or a notional reduction in rent calculation. So looking at that global calculation first, how do we come up with the global calculation? This can be done with the use of quantum reports in past cases to determine the appropriate annual rate for the seriousness of the disrepair suffered by the tenant. However, if reports of quantum in past cases are used, it must be borne in mind that awards for past cases must be adjusted for inflation, and also for damages that are awarded after the 1st of April 2013, a 10% uplift pursuant to the case of Simmons versus Castle must also be applied. It's also prudent to check, once the assessment on a global basis has been carried out, to cross-check it against a rent reduction calculation, because it can sometimes be difficult, even with the benefit of reported cases, to determine what is appropriate on a global basis. And the rent reduction calculation provides a more mathematical approach. just for the purposes of cross-checking or as an alternative. Now, looking at the rent reduction calculation in more detail, this is where the rent of the property is used as a basis to calculate the compensation. So here, the claimant will be awarded a percentage of rent paid whilst residing in the house or flat with disrepair. Even if the rent is paid by a local council in the form of housing benefits, a claimant can still claim compensation. The rent is used purely to calculate the value of the claim. And by way of using this calculation, there may need to be a need to calculate average rent, for example, if the rent during the period of disrepair has fluctuated or changed in any way. Now, in terms of assessing that rent reduction, it can be done either by reference to a particular period of time, with various items of disrepair applying during that particular period, or for each separate item of disrepair for however long that item was actually in disrepair. And there needs to be an assessment of the seriousness of the disrepair, and that's best done by looking at photographs or expert reports to determine a percentage reduction to the rent. Now, in addition to that, Stefan has already touched upon this, but it's also important to consider if there is a separate personal injury claim due to the disrepair. So as Stefan was saying, mold releases tiny spores into the air, which can trigger asthma symptoms in some people. Damp and cold can also produce bronchitis type symptoms. And it may even have the effect of causing an exacerbation of an existing condition. So for example, a person's normally well-controlled asthma may have been exacerbated during the period when the property was suffering from the dampness. In terms of how the courts quantify damages for personal injury, this is with reference to the guidelines for the assessment of general damages in personal injury cases. Current edition is the 15th edition. And there are sets of guidelines that set out, for example, an asthma bracket within that book. And that bracket is then split further in terms of both severity and length of injury, with differing values depending on how severe or how long an injury has lasted. It is, of course, guidance, and it is also useful to look at, in addition to that, reported cases with similar injuries, although ultimately it will depend on the specific facts of your own case. In this regard, it is important to bear in mind there can be contributory factors. So, for instance, there might be smokers in the house. If there is a finding that something like this has contributed to an injury, there is usually a percentage reduction in the award of damages for contributory factors. It doesn't, however, mean necessarily that the claim will fail in its entirety. And as Stefan has said, there is a limitation of 3 years for a personal injury claim. And it's important to bear in mind that the other side will have the right to request examination of the claimant by way of their own medical expert, and will have a right to access medical records, which are an essential part in terms of the medical records to establish onset of symptoms and to what they were initially attributed. So in addition to damages, so personal injury and general damages, a claimant can also claim special damages, which are any actual financial losses incurred as a direct result of the disrepair. So these can be things like damage to belongings or personal items, alternative accommodation costs, redecoration costs, increases in utility bills, etc. Now, the same principles of causation and mitigation apply. It is for the tenant to prove that they incurred the loss as a direct result of the disrepair. And if you are acting for the landlord, you will want to carefully check, for example, for evidence in support of the claimed costs. It may also be, for example, if damage to belongings is being claimed, clothing or otherwise, that a deduction may be appropriate in terms of wear and tear, if that's appropriate, noting the age of the item. So the tenant, in summary, in terms of special damages, needs to prove that the items claimed for were damaged beyond repair, the true value of those items, that they in fact did exist, and the cause of that damage, and the fact that it was related to the dampness. And that concludes my section in terms of causation and quantum. Just want to take this opportunity to thank you all for attending our talk today. Thank you very much for listening on behalf of the both of us. And please do feel free to send us any questions you would like by email. Our email addresses are on the last slide. Thank you very much for listening today.